He was untruthful about knowing what a 9mm handgun looked like when questioned what type of firearm he fired in the first video during the incident. His evidence in this regard cannot be true, as he owns a 9mm Taurus handgun and received training, according to his evidence, by the ANC regarding the handling of different firearms since the age of 9. I see there's a typo. I typed 19. That can just be amended to 9 years.
Thank you.
He lied about seeing people running after he fired the shots, despite this factor being and so obvious, as people could clearly see being seen running in the first video footage when he started to discharge the 9mm Glock handgun. It's our submission that that handgun was indeed the Glock that was produced when Colonel Janssen went to Tactical Security Services the first time that he went there. He lied about things that were so obvious about the number of shots being fired with a handgun, despite both experts counting 14, 15, around 14 and 15 shots being fired, and an additional 7 shots with the SPA 249. Accused 1 was provided with an tuber to count these shots from the handgun in the first video. He counted 20 shots being fired, and when probed how he got to 20 shots, he stated that he did not do accounting at school, but woodwork as a subject. He refused to answer more questions on this aspect and stated that he was not being charged for discharging a handgun and will only answer questions relating to the discharge of the rifle. It was clear that he was evasive and prepared to adapt his evidence as he anticipated the state's cross-examination on this issue. The state will argue that the 15 shots that were fired with that handgun are exactly the number of shots that are being discharged by a real 9mm Glock P standard handgun with a fully loaded magazine, as per the evidence of both ballistic experts. He was untruthful about knowing in which capacity accused number 2 attended the event and stated that he had no knowledge why accused number 2 was there during the incident. This is clearly a lie and contradicts his evidence regarding how and under what circumstances he met accused number 2 in 2008 at the University of KwaZulu-Natal. From all those firearms, 14, 12, 14, if my memory serves me correctly, Your Worship, I stand to be corrected, it's 28, it's for about 40 of those rifles that which he examined, or firearms that he examined, and this from that 40 is the only rifle that whose parts were changed. It's no coincidence that that bridge block was removed, because it seems to be important when it comes to the rest of the spent cartridge as to how positive tests would have been conducted or how a positive finding would have been received. How do you make a mistake from almost 40 firearms and you only one of those, the one who's been linked positively to this offense? I submit that, to me, in my view, that's no coincidence. It's been done deliberately so to affect the outcome of the ballistic test. Colonel Godleka found 3 markings at the neck area of the cartridge case that corresponded with the markings in the chamber or the barrel of SPA. The reason, therefore, he testified that that is part of the firearm, and it will be very difficult to change that barrel of a particular firearm. That's why he looked at the neck area. You need special equipment to actually take off that particular barrel and remove it from a firearm. It is submitted that the evidence of Colonel Godleka was not seriously contested. It was seriously contested, but it remains still unshaken. Thank you.
testified in his own defense and stated inter alia that he had utilized the stage gun that looked like a rifle. Now, Your Worship, let's pause here and accept my learned friend's invitation to draw inferences. So now we're not just dealing with the say-so, as Your Worship referred to it in cross-examination, but the actual under-oath testimony of the accused person. And the challenge, Your Worship, is there's nothing to disprove his version. If, by way of example, Your Worship, there had been some damage caused by a bullet nearby, then one could say he's lying because there is damage. Look what happened here. It's not the case. If the police, Your Worship, were on the stage and said there was a real gun, he's lying, then there'd be something to contradict it. If somebody else had found all these spent cartridges that my learned friend speaks of, or somebody had seen anybody picking up the spent cartridges, because now on the state's version we heard today, 26 shots were fired. So yet again, another rhetorical question is going to be, well, what happened to the spent cartridges? Why is there only one when 26 shots were fired? He argues that somehow, which we don't see on video, but the inference that he asks you to draw is that accused number 2 picked up those spent cartridges. There is no evidence, not oral, not alleged, not video, of him doing so. There's no evidence of accused number 1 picking them up. He goes even further. He says there's no evidence that blank firearms, and I'll show you the quote, Your Worship, emit spent cartridges. There's no evidence to the contrary either, Your Worship. It just was never canvassed. So one spent cartridge found at a large distance under where previous structures existed with respect doesn't cure or contradict the testimony of accused number 1 when he says, I used a stage gun that looked like a rifle. One cannot say, looking at all the inferences, where it was found, when it was found, what it is, how it's traced back with possible identificatory features of being a Remington spent cartridge, etc., that would fit into a Narinka rifle. I therefore can conclude that this is the actual cartridge that came out of that firearm for all of those reasons, because it's not the case. It goes against all the other objective facts. And he says, don't just look at Rex versus Blom, look at the other cases that say, look at the conspectus of all the evidence. And if we look at the conspectus of all the evidence, then one cannot contradict that which he testified to under oath. Second, he identified such a stage gun and handed it to Your Worship and the state to see the extent to which it looked like and felt like a real rifle. Thirdly, he further explained his personal security arrangements and how his close protectors operated. He even identified them by name and subsequently pointed them out under cross-examination when the video footage was played. Fourthly, the contents of the statements was put to him and he explained that they deposed to statements at the request of the state, not the defense. Nevertheless, they were not called by the state to testify. Fifthly, he further explained that he had brought a toy gun that he had received from the EFF Secretary General's office that had belonged to the EFF. Sixthly, he further explained that Larry Mavunda had handed it to him because it was his job to bring it there and carry it. Seventhly, he further confirmed that Larry Mavunda was present in court but refused to identify him. Eighthly, he refused to answer questions relating to a handgun because he had not faced any such charge and had prepared his defense on the charges defined by the magistrate as relating to a Narinka firearm and a Remington bullet. Ninthly, he was shown the video footage in slow motion and denied that anybody had run away in fear. Instead, he had seen people walking around and doing different things. They could not say what they appeared to be, that they appeared to be scared. In fact, they seemed to be cheering. Finally, he had never been approached to explain what firearm he had used and could have provided the blank gun for testing if he had been requested to do so. We then turn, Your Worship, to the state's heads of argument. I've dealt with some of these issues, but let's go through them in the light of my learned friend's latest argument.